General Court Martial is not a subordinate court within the meaning of Article 129(1)(d) of the 1995 Constitution. General Court Martial and other established under Article 210, whose jurisdiction is limited by Article 210(b) to handling matters related to discipline and removal of members of UPDF, including former and assimilated members of the UPDF, as stipulated under Section 1191A to F of the Act. Number 3, the jurisdiction of the General Court Martial and other military courts is under 210(b), limited to hearing matters involving disciplinary offences under Part 6 of the UPDF Act, committed by members of the UPDF as defined in paragraph B, and is also limited to the imposition of disciplinary sanctions to the members of the UPDF found guilty, as I have already stated. I enumerated the offense, the punishments earlier on. Jurisdiction of the General Court Martial and other military courts does not extend to hearing cases involving civilians who are neither former or assimilated members of the UPDF, as defined in paragraph B. The hearing of cases involving civilian non-members of the UPDF falls within the jurisdiction of courts of judicature established under Chapter 8 of the 1995. The hearing of cases involving members of the UPDF, as defined in paragraph B above, for the commission of offences under Part 6 of the Act, and where it is appropriate to impose a sentence of imprisonment or a more serious sentence, falls within the jurisdiction of courts of judicature established under Chapter 8. The hearing of cases involving members of the UPDF, as defined in paragraph B above, for the commission of general civilian offences created under any enactment other than Part 6 of the UPDF Act, falls within the jurisdiction of the courts of judicature established under Chapter 8 of the Constitution. Section 2, 1191H and G, and Section 179 of the UPDF Act, in as far as they confer jurisdiction on the court martial and other military courts to the constitutional limits, contrary to the constitutional limits described above in this judgment, are unconstitutional and null and void. I would make the following orders, in addition to the ones which I adopt from the Honorable the Chief Justice, which are in his judgment orders. In the draft judgment which I read, there were orders 1, 2, 3, 4, 5, and 7. I would just add that going forward, only cases involving members of the UPDF and related to disciplinary offences under Part 4 of the UPDF Act should be tried by the General Court Martial and other military courts, and that only the disciplinary sanctions as described at C above can be imposed by the military courts in those cases. Number 2, where a military court determines that the imposition of a more serious punishment, such as imprisonment or the death sentence, is necessary, in addition to removal from service, the military court shall forward the case filed to the Director of Public Prosecutions with a recommendation for institution of criminal proceedings in a competent court of judicature. I'll adopt the order made by the Chief Justice on the respective effect or otherwise of this judgment. Otherwise, I would award costs of the appeal and the cross appeal in this court and the costs in the Constitutional Court to the respondent.
Now we will now have Honorable Justice Mike Chibita deliver his judgment.
Thank you, Honorable Chief Justice, my lords, ladies and gentlemen. I've read the lead judgment of Winyidolo Chief Justice in draft. On the whole, I agree with the spirit, findings, declarations, recommendations, and orders. Before delving into the substance of the judgment, let me deal with one preliminary point of public interest. As one of the surviving members of the original panel that first heard this matter, I reiterate the explanation that unprecedented occurrences indeed hindered and stood in the way of the expeditious disposal of this appeal. The retirement of Honorable Justice Ezekiel Mhanguzi and the deaths of Honorable Justices Opio Aweri and Stella Rach Amoko, all of whom were members of the original panel, ensured that reconstitution of the panel was inevitable. It was not until Honorable Justices Catherine Bamugemereire and Monica Mugenyi, Justices of the Supreme Court, were appointed in 2024 that a full panel could finally be reconstituted. Suffice to say that any delay in dispensing justice is always regrettable, whatever the cause. The larger principles at play in this case are the age-old principles of the jurisprudence of criminal law. It is universally accepted in the common law system to which Uganda subscribes that the presumption of innocence is a bedrock of our criminal law. And this has been incorporated in the 1995 Constitution of the Republic of Uganda under Article 28(3)(a), which states that every person who is charged with a criminal offense shall be presumed to be innocent until proved guilty or until that person has pleaded guilty. In other words, everybody is presumed innocent until proven guilty by a competent court. What we are investigating in this case is whether the court-martial is a competent court to try civilians or anybody else brought before it for that matter. Other guarantees of justice and fairness in criminal proceedings are the right to a fair trial and the right to a fair hearing as stipulated under Article 28(1) of the said Constitution, which reads, in the determination of civil rights and obligations or any criminal charge, a person shall be entitled to a fair, speedy, and public hearing before an independent and impartial court or tribunal established by law, close quotation. So the question is, does the General Court-Martial guarantee these fundamental freedoms? The answer, as far as civilians are concerned, has been found to be largely in the negative. In accordance with the doctrine of precedent and in view of an earlier holding by this court, the conclusion in Attorney General versus Joseph Tumushabe that the General Court-Martial is indeed a subordinate court as contemplated under Article 129(1)(d) of the Constitution is still good law. Secondly, that Section 117(1)(g) of the UPDF Act does constitute exceptional circumstances under which the trial of civilians in military courts would be justified, and to that extent is not inconsistent with Articles 28(1) and 44(c) of the Constitution. However, I agree that Section 117(1)(h) of the Act is to be found void for vagueness and therefore inconsistent with Article 28(1) of the Constitution. On the issue of remedies regarding matters pending before the General Court-Martial involving civilians, I would agree that they will be remitted to the civilian courts for consideration. And in regard to trial of members of the military, I agree with the recommendations given to the Executive and Parliament to work on the necessary amendments in order to bring the court-martial in conformity with the Constitution. I'm persuaded by the doctrine of prospective annulment as opposed to retrospective annulment as laid down in the case of Calista Andrew Mwatela and two others against the East African community, which was applied in the case of Bob Kasango against Attorney General. The same principle was held in the case of East African Law Society and four others against Attorney General of Kenya and three others. The court declined to invalidate amendments found to violate the treaty. Court, however, invoked prospective annulment and declared that involvement of the people in the treaty amendment process would have prospective application. In the case of A against the governor of Abba Hill Prison, the Supreme Court of Ireland held that the declaration of unconstitutionality of a law has prospective effect only. It was further held that the court cannot interfere with final decisions of the courts, even if based on a law later to be found unconstitutional. Otherwise, retrospective annulment or retrospective effect, as termed elsewhere, would create an absurdity which the courts can and should never intend. Dated at Kampala, the 31st day of January 2025.
Now we can ask Lady Justice Twice to deliver her judgment.
Thank you, my Lord Chief Justice. We'll proceed to read my judgment as follows. I have had the benefit of reading in draft the lead judgment by Alphonse C. Owindolo, Chief Justice. I agree with the analysis, decisions, conclusions, and orders that are proposed in his lead judgment. The background to this appeal and the respective cases for the parties to the suit have been ably articulated in the lead judgment and in other judgments prepared by my land sisters and brothers in this appeal, which I have also had the benefit of reading in draft. It is therefore not necessary to reproduce the same. I will only add my opinion regarding the issue relating to the capacity of the I will only add my opinion regarding the issue relating to the capacity of the General Court Martial to render a fair trial as envisaged in Article 28(1) of the Constitution of Uganda. The jurisdiction and competence of the said court is challenged by the respondent in this appeal. The appellant, on the other hand, contends that it is a court of competent jurisdiction provided for under Article 210 of the Constitution of Uganda and Section 197, now 195 in the revised edition, the year 2023 of the Uganda People's Defense Forces Act. The appellant also, in opposition to the respondent's assertions, contends that the establishment of the General Court Martial does not contravene Articles 28(1), 126(1), 129(1), 210 and 267(1)(d) of the Constitution of Uganda. The General Court Martial is created under Section 197, now Section 195 in the revised version of the laws of Uganda, of the Uganda People's Defense Forces Act. Its long title reads, among other things, that it is an act, I'm quoting, to provide for the regulation of the Uganda People's Defense Forces in accordance with Article 210 of the Uganda Constitution and for other related matters. It is a specialized court in the sense that it was created to exercise jurisdiction over specified matters relating to offences created by the UPDF Act, committed by members of the military forces and persons who aid or abet such offences. In short, to administer military justice in Uganda with jurisdiction to handle offences specified in the Act, mainly for penal and disciplinary purposes. The General Court Martial was therefore established as a specialized court of the military forces. On the other hand, the Constitution also establishes courts of judicature empowered to exercise judicial power with various jurisdictions under Article 129 of the Constitution, which states that the judicial power of Uganda shall be exercised by the courts of judicature, which shall consist of A, the Supreme Court of Uganda, B, the Court of Appeal of Uganda, C, the High Court of Uganda, and such subordinate courts as Parliament may by law establish, including Cadi's courts for marriage, divorce, inheritance of property, and guardianship, as may be prescribed by Parliament. 2, the Supreme Court, the Court of Appeal, and the High Court shall be superior courts of record, and shall each have all powers of such court. And 3, subject to the provisions of this Constitution, Parliament may make provisions for jurisdiction and procedure of the courts. Both the courts martial and the courts of judicature therefore have their origins from the Constitution, save that while the Constitution directly sets up the courts of judicature under Article 129, the courts martial are set up by an Act of Parliament as mandated under Article 129(1)(d) and 210 of the Constitution. The criteria for appointment of members who sit on the General Court Martial, set out under Section 195 in the revised version of the Laws of Uganda 2023 of the UPDF Act, is that they should essentially be army officers, with the chairperson not being below the rank of a Lieutenant General, save for the chairperson of the court of the Court Martial Appeal Court, who is required to be an advocate qualified to be appointed as a judge of the High Court. Legal qualification is not a basis for appointment on the General Court Martial and the other military courts set up under the UPDF Act. In contrast, under Article 143 of the Constitution of Uganda, persons qualified for appointment as judicial officers to the courts of judicature as established under Article 129 of the Constitution of Uganda must have legal qualifications. It is to be noted that both the General Court Martial and the courts of judicature, particularly the superior courts, under the respective laws that govern them, as well as the penal laws, either in the exercise of their original or appellate jurisdiction, are empowered to pass the death penalty, which is the maximum punishment a court of law would pass. It is also noted that under Article 123B of the Constitution of Uganda, the Director of Public Prosecutions, who is the officer charged with the function of, among others, instituting criminal proceedings against any person in that court, is exempted from instituting such criminal proceedings in a court-martial. The contradictory position is that while under the UPDF Act, qualification for appointment to the General Court-Martial does not require one to have legal qualifications, persons qualified for appointment to the position of a judicial office in the courts of judicature are required to have legal qualifications under Article 142 of the Constitution. Secondly, the conducting of criminal trials in the General Court-Martial, unlike in the case for courts of judicature, is not controlled by the Director of Public Prosecutions. The interests of justice and fairness require that any court that is empowered to pass a penalty for a penalty as serious as a death penalty, or even, I dare say, imprisonment, should be presided over by competent persons with legal qualifications. The criminal prosecutions conducted before such courts should ideally be controlled by the Director of Public Prosecutions. This would be a safeguard for a fair trial envisaged under Article 28(3) of the Constitution of Uganda. In addition to the International Covenant on Civil and Political Rights, to which Uganda is signatory, and all other international human rights instruments, binding or persuasive, which have been ably highlighted in the other judgments to this appeal. In my considered opinion, it would not matter whether in actual fact, that is de facto, the members appointed to sit on the General Court-Martial, in the wisdom of the appointing authorities, do possess the legal qualifications to be competent to adjudicate criminal matters, especially those attracting heavy penalties. As long as the UPDF Act that creates the General Court-Martial does not expressly include legal qualifications as a requirement for appointment to the General Court-Martial, that is de jure, the competence and capacity of that court to handle criminal trials would still be questioned as is being done in this appeal. This is based on the cardinal principle in our legal system that justice must not only be done, it must be seen to be done. The General Court-Martial would only be competent to adjudicate over criminal matters of not only civilians but also military persons if it were a court of law with the requisite structures to conduct a fair hearing as envisaged under Article 28 of the Constitution of Uganda. There can be no fair trial as envisaged in Article 28(1) of the Constitution in an incompetent court. It is in that regard I would, with respect, not agree with the appellant's contentions that the General Court Martial is a court of competent jurisdiction to hear criminal matters. In its present state, the General Court Martial, though lawfully set up by an Act of Parliament deriving such powers from Article 129(1)(d) of the Constitution, is in its present form competent only to handle matters relating to discipline of members of the armed forces. In the result, based on the above, and in addition to the reasons, decisions, conclusions, and recommendations for legal reforms stated in the lead judgment, which I associate myself with, I would conclude that this appeal fails, save for the issue regarding the establishment of the General Court Martial as a court of law. I would dismiss it to that extent and allow the cross appeal. I would award the course of this appeal to the respondent in this court and in the courts below.
Thank you, my lord.